Hello, you're watching Tell It Like It Is, and my name is Kathy Benuck. Well, you know, those of you who watch Tell It Like It Is regularly, and I hope that's all of you, know for the most part that this show does tend to deal with issues, local, state, and national, and issues that are important, issues that affect us. Most of the time they're controversial, at least in some form, and they're issues that we need to know about. The other part of the show, for the most part, deals with interviews with people who are decision makers or who are playing some kind of a role in some of those issues. And that even includes political candidates who are striving to become part of those issues. Today's show is a little bit different in that it's going to tell a fascinating story, a story in which a Bedford, New Hampshire resident played a very huge role. I'll tell you now, it's a classic David and Goliath kind of story. It's a story in which an ordinary person got trampled by a business at a time when his life really was kind of full of woe, so to speak. It's a story of somebody getting knocked down, getting kicked when they were already down, a man that really didn't have any family members or friends nearby to help protect him. It's a story of a landlord, a very big and well-known landlord, who, at least in my opinion, failed to protect a very good tenant. It's a story that involves some greed, and it involves some big twisting of truths. It's a story that has all kinds of twists and turns. And you know what? It's a story that has lasted now for almost 7 years, believe it or not. It's a story that at some point will truly make you question the wisdom of the whole legal system. It's the story of a little guy who was dealt a bad hand that went all the way to the U.S. Supreme Court. And it's the story of a Bedford, New Hampshire resident and lawyer who did what very few lawyers ever get to do in this country, and that's argue a case before the U.S. Supreme Court. So, my guest today is someone who's a very familiar face to many of you, and that's Atty.Brian Shaughnessy. Brian is a native of the greater Boston area, the son of two parents who labored very long and hard to make sure that every one of the kids in their large family would be well educated and grow up to make a difference in this world. Brian decided to pursue a career in law, and ultimately he has since become a very well-known, well-respected attorney in his own Manchester-based law firm, which is Kazin, Shaughnessy, Caston, and McDonald. He's a longtime resident of Bedford and has become a familiar face for a lot of reasons, through a wide retinue of volunteer activities, through his charitable work, through big involvement in local sports, and even through sportscasting on BCTV of Bedford High School athletic matches. And in 2012, Brian was elected as Bedford's town moderator and earned his stripes within very short time of that happening when he presided over the 2012 presidential election. What a lot of you don't know about Brian is that 1 year ago, almost, we're getting up to the anniversary, in 2013, Brian did what lawyers can only dream about. He argued a case before the U.S. Supreme Court, and he won. Unbelievable. Today we're going to talk about that, and we're going to find out from Brian what it was like to appear before those who uphold the laws of this entire nation. Brian, I know you had a court thing going on today. I can't tell you how happy I am you're here and made the time to be with us.
Well, pleasure to be with you, Kathy.
It's an amazing story. I know that it is not one that everybody knows. And that's why I approached you. Gosh, before you even went to the Supreme Court, when I heard you were going, I approached you and said, Brian, come on, you got to do a show with me. And you promised, and you're making good on it. So I guess, I mean, what I'd like to do is kind of set this up so that we can start at the beginning, and you can, by the end of it, people will know, because it's a really convoluted story.
It's a simple, factual story that takes a complicated and torturous path.
Indeed, indeed. Now, let's start with, why don't you tell us a little bit about the main person in the family, in the story? I did not mention his name because I wasn't sure if you wanted his name mentioned on the show. So that's entirely up to you.
Well, it's all a public record right now. If people Googled the case of Robert Pelkey versus Dan City Auto, they would come up with not only the Supreme Court decision, but probably several other news stories or whatnot. So it is public record. And
he's of Manchester, New Hampshire, correct?
Correct. And Robert Pelkey has been a client of mine for a number of years, so he's known to me. And as you said in your introduction, he's a gentleman who has no family locally. He was never married, had kids, so for a long period of time, I was one of the few contacts that he had in the Manchester area. And he was living, at the time that this story begins, in Colonial Village in Manchester.
That's a pretty well-known place.
It's a very big apartment complex on the north side, right along the river.
Yeah.
So there's many apartment units in there.
I mean, that's a corporation. I don't think that's the only complex they own either.
Well, it's been managed by a large management company that manages other large apartment complexes. And you're right. I think the ownership there also owned, other apartment complexes as well.
Wow. The story, from what, and you provided me with a ton of paperwork. I cannot believe the paper you lawyers generate. But in any event, from what I gathered, kind of looking it all over as a non-lawyer, the story started on or about February 3rd, all the way back in 2007, right? Yeah,
I mean, the story's simple. A man's car got towed from a handicapped parking spot in the parking lot of his apartment complex.
Of his own complex.
Of his own apartment complex. It was a handicapped spot. He had a handicap plate. He's had some mobility impairments for a period of time. And so he had been parking there for several years prior to his car getting towed. So while factually the simple part of the story is his car got towed out of a parking spot, what happened after that is what complicates matters.
And he had the right to be parked there. His car was duly registered. He had a handicap plate.
Well, there's no doubt.
I assume he was also known to the management because he had lived there for a number of years, correct?
Yeah, he had, a parking sticker. Yeah. And there's no question that he was legally parked there. The question becomes is, many times, I represent a lot of landlords in New Hampshire, and wintertime is very difficult for the landlord-tenant relationship because parking lots have to be plowed.
Sure.
And so there are rules that each complex has that say when it snows, you have to, move your vehicle. In fact, just this past weekend, there was a story in the Union Leader about a person from public housing in Manchester whose car got towed, and she was $10 short of the fee, so it got taken away, and she lost a day of work. And we're dealing with the same issue in this case, okay, in that it's a question of fact as to whether there was a significant enough snowstorm to actually cause the plowing of the parking lots.
But what had generally been his way of handling that requirement, where he did have a handicap?
The first several years he was living there, he had no problems moving the car himself. But he did have some health issues that we will probably talk about a little bit as we get along in the story. Okay. But he had some health issues, and he would actually ask a neighbor to move his car for him. And the way it worked over at Colonial Village is they had various parking lots that would get towed at various periods of time. So, for example...
Oh, kind of like a sequential?
Correct. So Building 3 or Building 4, they know that if there was a snowstorm the night before that produced more than 2 inches of snow, that their time would be from 10 o'clock to 1 o'clock, or I'm not getting the times
particularly.
Oh, wow.
It was even on a set time.
Right. Set time that you have to move your cars during that period of time, or it could be subject to being towed. So what he would do is if he was not able to do it, he would have somebody move it over to the overflow parking lot. So Colonial Village had a different parking lot where you could move your car temporarily while the main parking lots are being towed. So he would have somebody move it there and move it back. So he at one point asked Colonial Village, because of his mobility impairment, whether they would accommodate him and not apply this parking policy or the plowing and towing policy to him because he was handicapped. They said that they could not help him move his car, and that's typical of many large landlords. They're not in the business of moving cars. Yeah, but there is a Fair Housing Act and reasonable accommodations that would suggest that some landlords have to actually accommodate and modify their policies. I do a lot of disability work and fair housing work as well. Now, on that particular day where he had always made arrangements, what happened? Did they change the time they plowed, or? Well, here's where there's a factual dispute. Mr. Pelkey would, indicate that on February 3rd, which unfortunately happens to be a Saturday, he did not believe that there was enough snow to actually trigger the plowing of the parking lots.
Okay.
He could look out his window and see the snow still, I mean, the grass still, poking up from the snow, so there wasn't enough snow. But unfortunately, Mr. Pelkey was at that point in the process. He was very sick, and in fact, within a week of that date, he was actually hospitalized for several months, which we'll get into in a moment.
Okay.
But he was basically bedridden, and he had to pull himself up to even look out the window to appreciate. Okay, it's snowing. Do I have to plow or whatnot?
Yeah.
Now, he's a very detailed and fastidious type of man, so he was worried about whether he'd have to get his car moved or whether it was going to be plowed. So he called into the office. But again, it being Saturday, he got the answering service. So he has a conversation with the person from the answering service, say, well, I see it's snowing out there. I don't think that they're going to plow. Can you tell me, are they going to plow today? He says, well, sir, I'm not in the manager's answering service. I'm not there. I can't tell you whether it's going to plow or not. So he couldn't get through to the office. In the past, if it was snowing during the week, he'd call the office and talk to them. Are you going to plow? And then he would make the arrangements with the neighbor. So he was unable to do that in this particular case because it was a Saturday. So he made the independent determination, well, it's not snowing hard enough, so I can't. He, at that point, essentially, again, was bedridden. There was no way he'd be able to physically get out and move that car that day himself.
And, I mean, the apartment complex, I mean, that's a place that has hundreds of residents.
Yes.
I mean, is everybody kind of basically on their own on weekends? That they're just going to talk to an answering service? That doesn't seem right. Well,
there's really, that's a catch-22. There's really no good way for a landlord to deal with a plowing policy that way, especially in the bigger complexes. If you have one or two cars in the way, they need to get their contractors in and plow it in such a way as to not create mounds of snow all over the place, which then melt later and create some maintenance problems.
No, I understand that, but it just seems as though any resident should be able to get somebody connected with the complex, no matter what the reason might be, on a weekend.
Well, and most of them do have emergency calls for maintenance and things like that. I don't know that that would apply to whether it's going to be plowed or not. I think the landlords would say, well, when in doubt, you should, move your car, or I guess be there, physically be there to end. But that doesn't account for there's many people that are elderly.
Of course.
Or mobility impaired, they can't do that. I work with a lot of subsidized apartment complexes, housing authorities, and because they're federally funded under the Fair Housing Act, they would be required to accommodate those tenants. And we've made reasonable accommodation plans where the person would be able to call up this telephone number, and then they would, have somebody else help them. They've had maintenance people help them move their cars, or they say, all right, we're going to be coming, so you move your car to this lot, stay in it while we plow at your place and come back. There are different ways to attack the problem, but it is it's a perennial problem in any type of landlord-tenant business.
But one would think, I mean, at the very least, if there was going to be a towing, that somebody would knock themselves out and knock on his door and say, you've got 20 minutes to move the car or something. Yeah,
the article that was recently, I'm not sure when this will air, but the article this past weekend, and right now we're here at February 10th, so this happened, I think, on the most recent snowstorm, where the woman said that it was Manchester Housing Authority was the landlord in that case. They would actually, blow the horn outside to let people know, hey, we're going to be plowing.
Some kind of signal,
and then they said that people would knock on their door. She did not hear the knock on the door in this particular case, so they warned them.
Reasonable.
Yeah. But where he was living, it's not subsidized community, and there was no such notification. It's basically when you moved in, you got this sheet of paper, and they would send out yearly, newsletters and reminders with, here's the rules. Remember, you have to move your car or it might be towed. The difference here is it was in a handicapped parking spot.
Yeah. And I mean, that to me shades that story a whole bunch.
Yeah.
So now he's in his apartment, and for all intents and purposes did not even know that they were towing his car, correct?
Correct. And
it was towed.
Yes.
So when did he finally find out? You said he was bedridden and did go into the hospital.
Right. Well, what happened is about a week later, within a week of February 3rd, he was hospitalized. He has some health conditions which led to the amputation of his leg. So his right leg below the knee was amputated. And that was one of the problems he was having. He couldn't get up because of the problem with his leg, which was why he couldn't actually physically get out and move his car on February 3rd. But as he was recuperating from that operation, he suffered a heart attack. And so it was 2 months before he was released from the hospital. So sometime around just shy of maybe April 15th or 16th, I forget the particular date, he gets released from the hospital. Now, again, this gentleman has no local family. He has nobody else who actually helps him out. I was actually in the process of helping him out with a landlord-tenant matter having to do with Colonial Village. So we were in the process of a battle, if you will, with Colonial Village already. And he called me up as he was coming home. And when I came over to visit him, he said, "Did you see my car?" And I said, "No, it's not out there." So I went looking.
I didn't even know yet it was gone.
Didn't know. So I was the one who discovered his car got towed because it wasn't there. I called the management company and I said, "Hey, did you guys have his car moved to the, the overflow lot? Is it up there?" Because my client tells me that's what happens sometimes. He thinks it might be up there. They say, "No, we didn't do that." Well, hang on a second. So they called their attorney up.
Their attorney?
Their attorney, because again, I was involved in litigation with Mr. Pelkey and Colonial Village already. All right, there was an eviction action going on as well, not for non-payment of rent. This guy would never not pay his rent. But there was another issue going on, and we were in the middle of it. We actually had to have an eviction action continued during this period of time because he was in the hospital.
Good.
So the landlord knew he was in the hospital.
Yeah.
Okay. They apparently
that's a big point.
Didn't know that the car had been towed because what they do is they have arrangement with towing companies that say you can come in and if people are there when they're not supposed to be, you can tow. So they tell me that they didn't know that Mr. Pelkey's car got towed. So when I called them, they called up the attorney. The attorney calls me and says, "Oh, well." Rather
than the towing company, they called the attorney.
The attorney calls me up for Colonial Village and says his car got towed a long time ago, and in fact, in 2 days, it's going to be auctioned off for non-payment of the towing fees. So the first he knew his car was gone was 2 days prior to this auction, and it was me finding out that the car was now being auctioned by the towing company to pay for the tow and the storage fees that accumulated over the past 2 months.
Which probably was pretty big at that point.
Significant, yeah.
Now, aren't there state laws that deal with that? I mean, somebody can't just whiz away your car and all of a sudden sell it and you don't even know it.
Well, here's the state laws allow a private owner of property to ask that the car be towed or removed from private property. Number one, a police officer can have a tow company come and tow somebody from a place where the car shouldn't be, or from the public way, or if it's been an accident. And but by the same token, a private landowner can have it towed from their private land. Once it's towed, this is where the state laws come in effect, and they basically regulate the towing company and the storage of the vehicle. All right. So there's certain criteria have to be met when a car is being towed. So if it's by a police officer, one set of rules. If it's by a private owner, the police have to be notified. And usually the arrangement is the towing company notifies the police.
Was that done in this case?
There's no dispute that they may have notified the Manchester police at some time that they towed the vehicle. And the reason for that law is when the person finds their car missing, what are they going to do? They're going to say, "Hey, my car is gone, somebody stole it." So the police would have a log to show, "Oh no, this got towed, go call Dan City or go call Queen City Towing," or go, so they'll know where to locate their car. So there is a requirement that the owner of the property notify the police. Oftentimes, the way this works is the owner has the contract with the towing company, and because the towing company wants the business, they take over that role and will notify the police that, "Hey, we've towed the car from so-and-so parking lot." So there are state laws that require them to do that. Now the next step is if a car, once it's towed, the towing company or the storage facility has a lien against the vehicle. And so unless the amount is paid to the towing company for the storage or for the tow, they don't have to release it. So they basically have a lien against that property. They can hold it until they're paid their fee. In the city of Manchester, not a state law, but city of Manchester does have a regulation that if a car is towed what they call non-consensually, without the consent, so if the owner didn't call up and say, "Hey, tow my car," somebody else did, there is a limit on the storage fees that can be charged and the type of fees. Yes. They have a limit on the actual towing fee and a limit on the storage fee that can be charged by the storing facility for a period of time. So that's the Manchester City Ordinance. And so the cities can regulate that, subject to the federal law we're about to talk about in this case, which then puts the wrench in the, it really, people don't know about this federal law that limits what can or cannot be due to the towing services.
Now, in here, we already know that he did not know until he got out of the hospital that his car had been towed. Through your effort, you were able to find out it was what happened, and that 2 days hence, from when you were talking with their lawyer, that the car was going to be sold. Isn't there any kind of a requirement that somebody had to, with some kind of due diligence, locate the owner or notify him that this was going on? I mean, he did legally own the car. He did have it registered, so it's not like it was just some vehicle sitting out in a field with no plate and maybe the VIN scratched off or something. So,
well, there's a requirement. That's an interesting and insightful question, because one of the weaknesses of the law is there is no apparent requirement that I could ever find that would require the towing company to contact the person directly and say, hey, we towed your car and we have it.
okay. But what about when it reaches the point where legally they can junk it, sell it?
Right. So the
whatever.
next step is if there is unpaid, if there's unpaid fees, or let's say the car was abandoned and got towed because it was abandoned. There's a process by which the towing company or storage facility can sell the vehicle. There's a state statute that applies.
After what, so many days or
right.
what have you?
And then they have to notify the owner saying, here's the fees, we have it, and we're going to sell it at public auction.
And that is by statute.
Yes, and they have to notify them by certified mail.
Now, at that point, the owner still has the option of going in and anteing up the money and getting their vehicle back.
Correct.
Okay.
Yes.
Now, they didn't do that with him?
With him, this, again, took a twisted and torturous path. Once I talked to the attorney, as soon as I talked to the attorney and identified that Dan City had towed it, I notified Dan City immediately the situation. I represent this gentleman. It got towed out of a handicapped parking spot. He's been in the hospital. Could you please send us the bill? Because he wants to pay for the towing and the storage. He wants to retrieve his vehicle.
Now, this was not some old clunker either, correct?
No, this was a new car. It was had under about 8,000 miles on it. It was a Honda Civic.
So obviously the guy wants it back.
Oh yeah, it was a late model. It was probably a year or two old, and it was worth money.
So were you able to run down there with the check?
Well, no. Within the next day or two, again, this was 2 days shy of the sale.
Yeah.
And so I sent over the notice with every anticipation I'd get a bill, and that would take it off the auction block.
Yeah.
When I contacted Dan City after the auction date, they said, well, it's too late. They told me it had been sold at foreclosure sale at the auction.
Wow.
That ended up not really being the case. They never really sold it at auction.
Okay.
I didn't know that this car was never sold at the auction until 6 months later, until after I had already filed suit in this case. All right.
But
so
had they
done
everything they were supposed to do with regard to even letting him know that car was going to get sold?
No. That's our allegations. Again, this case is still going to go to trial in the beginning of March.
Okay.
And we're sitting here in the beginning of February. So these are contested facts. But what they did is there is a requirement that they notify somebody by certified mail, hey, your car is going to be sold in order to pay X amount of dollars. If you pay X amount of dollars before the sale, then they would take the money and give your car back. They first tried to get permission from the state of New Hampshire. They filed a form with the Department of Motor Vehicles saying this car is abandoned and we want to sell it. It's worth less than $500.
Even though it had current plates and inspection sticker and everything.
And we want to sell it without notice to the owner. So even though it was registered, it's got a sticker from Colonial Village identifying who the owner is. It was towed from the very place where the gentleman lived.
And a late model car.
Late model car with no loan on it.
Wow.
Because otherwise the mortgage, the loan holder might have something to say about it.
Yeah, true.
And it was in a handicapped parking spot. So with all of that information, they were telling the Department of Motor Vehicles that, well, it's worth less than $500, it's abandoned, we don't know who owns it. The Department of Motor Vehicles says, oh, no. Robert Pelkey owns it. Here's his address,
Wow.
which is the address of where it was
Yes.
towed from.
Yes.
Surprise, surprise, right?
Yeah, big surprise.
So they sent him a letter, but they don't send him a letter saying we're going to sell it at foreclosure or at the auction. They sent him the other boilerplate letter they probably have in their word processor that says, your car is abandoned. And it's illegal to abandon cars, and you might owe us some, fees. That's it. So they sent him the wrong number. They never told him that it was, the letter they sent out never told him that it was going to be auctioned. Now, here's the other twist
Now,
and turn.
wasn't he in the hospital?
Yes.
So he never would have seen the letter?
No. And the other twist and turn was because he was in the hospital
Yeah,
and because he has no family,
yeah,
his mailbox got stuffed full.
yeah.
The postal started not delivering the mail anymore. So that certified mail never got to him. And somebody, we don't know who, Mr. Pelkey has his theories as to whom, notified them that he moved with no forwarding address.
Good grief.
He hadn't moved. Everybody knew where he was. Everybody knew he was represented by me. So that's one of the little factual things in there that makes this a case that gets my temper up a little bit.
So they sold the car?
Well,
Maybe. Maybe not.
about 6 months later, in October of 2007, come to find out after I filed suit and whatnot, what they did is the owner of Dance City traded it in, used it, and got credit so he could go buy a, $80,000 sports car
For himself?
for himself.
You've got to be kidding.
No. He traded that and
Isn't
another
that
car
outright
in.
theft?
Well, when we go to trial, I'm saying it's a violation of the Consumer Protection Act.
It's a violation of something.
It's unfair and deceptive trade practices, which is the very issue that went up to the U.S. Supreme Court, whether I can sue a motor carrier under New Hampshire's Consumer Protection Act. So the facts, I think, set it up for an interesting case as to whether it's unfair or deceptive trade practices.
Unbelievable.
But I got blocked by this federal statute that no
So
one
you
really knew
did
about.
file suit.
I did.
Now, where would you have filed suit? Like locally, a district court,
We
something like that?
filed it in the Superior Court.
Superior,
So this is Manchester, that's Hillsborough County. So it was the Hillsborough
Okay.
County Superior Court.
Yeah.
And it was a lawsuit alleging very things that you've already said. They had a duty to find out who he was.
Yeah.
They had a duty to, once they knew who he was, not sell it again, I thought it was sold at auction in April. So when I was
So they
filing the
outright
lawsuit,
lied. I mean, they outright lied that it had been sold.
they outright lied to me.
Yeah.
But that's a factual
that's
thing
kinda
that hasn't been
serious.
determined yet, that they said it had been sold when it hadn't been. But in the lawsuit, I was saying there was negligence, they didn't comply with the statute, and then I was saying that they had a duty to warn him. But there's also a suit against Colonial Village, and this is where we get the tow company and Colonial Village pointing the finger. Colonial Village says that, hey, we didn't do anything wrong. The tow truck company says, no, they came out and pointed to that vehicle and say, tow it. So again, as I told you, Colonial Village and Mr. Pelkey were already in a battle. So that's a factual dispute. Why was it towed or when and whatnot. But then in the Superior Court, we were probably, I don't know, a month shy of the trial. We had waited 1.5 to 2 years to get to our
All that
line
time.
for a jury trial.
And this poor man, meanwhile, has no car,
He had no car.
no money for his car.
He, well, at that point he had an amputated leg too.
Good God.
And he wanted to get a new vehicle, but I'll tell you, he was deathly afraid that somebody was going to tow his car.
Well,
after that.
yeah,
So,
I would think.
so when it gets to the Superior Court, after several motions for summary judgment, back and forth, the usual litigation thing goes on, they file a motion for summary judgment saying that there was this federal law. It was the Federal Aviation Administration Authorization Act of 1994, which applies to motor carriers. It's a federal law that applies to all motor carriers throughout the country. Tow trucks are considered motor carriers. So while Dance City doesn't probably tow vehicles across state lines, this federal law under the Commerce Act now applies to the tow truck company. And what that says is the actual statute says that a state cannot enact or enforce a law, regulation, or other provision that has the force and effect of law that relates to a price, route, or service of any motor carrier. Okay?
Oh, is that a stretch?
Okay. What that law was it was a deregulation of the motor carriers,
Yeah.
the same way they deregulated in 1978 the airlines. And so what
That
they're
is like
saying
a
is,
huge stretch.
if you have these interstate trucking companies, you don't want the state of New Hampshire having one set of rules, but then when you cross into Massachusetts,
Yeah,
you haven't complied with
exactly.
those set of rules, and then,
Exactly.
that's what it's supposed to, that's what the whole act was supposed to be about. But
So they tried to dodge everything by that.
they brought that up saying, you're preempted. You cannot actually file suit against us under New Hampshire's Consumer Protection Statute because that's a state law. And so now the state is enacting a law that regulates the tow company, which is a motor carrier.
And did that work?
In the
court?
Superior Court, it got dismissed. The
It got
case got
dismissed.
dismissed. So I lost at the Superior Court level because the Superior Court judge essentially ruled the same way as another state's Supreme Court had. There was another state Supreme Court that had,
Not New Hampshire.
not New
Other
Hampshire,
state.
had looked at this issue and they said, yeah, these types of lawsuits are preempted. So the Superior Court judge adopted that rationale as opposed to other rationales and interpretations that I thought were more reasonable, and dismissed the case.
So you had to have appealed.
I appealed that to the New Hampshire Supreme Court.
Supreme Court, okay.
So we went up to the New Hampshire Supreme Court. I won the case at New Hampshire Supreme Court.
Okay.
Then from there, the attorneys for Dan City appealed it to the U.S. Supreme Court.
They're the first, really?
They're the ones who brought it up to the U.S. Supreme Court.
Really?
I did not bring the case up to the U.S. Supreme Court because I won at the New Hampshire Supreme Court. What would happen is the New Hampshire Supreme Court overturns the dismissal. I would then go back to Superior Court and have my day in court and try the case.
Now,
I haven't got the day in court yet.
Now, at this point in time, I mean, obviously the car was worth a whole lot more than $500, and I don't have a blue book, or nor am I a car
The blue book is
expert.
$12,000.
Yeah, I was going to say it had to be in the thousands, but now, by the time all this was going on, wouldn't Dan's auto legal bills probably be that or higher? Why would they keep going with this? Were they afraid of some kind of a criminal charge? I mean, it's almost surreal the length they were willing to go to.
That would be speculation on my part, and we
Yeah.
haven't gone to trial yet, and there's a couple things I'm holding in my back pocket that I'll use.
Yeah, I have to be careful, yeah.
But
I shouldn't have asked you that.
No, that's fine. But there's one thing is, behind the scenes, there was a battle between Dan City and their insurance carrier as to which claims would be covered.
Ooh.
Okay, so let's just use a simple example. If you run a red light and negligently hit somebody and injure them, your insurance is going to cover that. If you intentionally run somebody over to murder them, your insurance doesn't cover you because
Makes sense.
it's not an accidental
Yeah.
injury. So
Yeah.
there's this whole concept. There are some claims that could be covered by insurance, some claims that may not be covered by insurance. And the things that I was alleging, the deceptive trade practices, are more of an intentional.
Well, yeah.
And there's an issue over whether insurance coverage would cover those types of claims. So there was a battle going on.
And, I guess I'm a suspicious enough person to say, how many other times did they do something like this? Is this isolated, or are they, being so proactive to protect their butts because they've got maybe a history of doing things that aren't too good for people but good for them?
Well, your antennae are usually pretty accurate. And I have similar theory or whatnot that there was something more at stake for Dan City. I mean,
It would seem.
Dan City is on the Bedford police towing list.
They
They're
are.
on the Manchester City towing list.
Towing is very lucrative.
Yes.
I
After
mean,
this case came out, though.
there's a big thing going on in my old hometown about towing contracts and so on, and I was rather shocked to see the amount of annual dollars involved. It's big stuff.
It's big business because not only could it apply to, take the city of Manchester, you have these, the law that says there are snow bans are in effect. You can have hundreds of vehicles being towed in each
Absolutely.
each snowstorm just from the city. But then you go to the big apartment complexes like this case. I think on a typical snowstorm it's not unusual for 30 to 40 cars being towed, and if they're getting up to $185 per tow,
It's a lot of money.
plus if somebody is out of town for a couple days and they're charging anywhere from $40 to $80 in storage fees. And now they have
Huge money, and that's money for nothing, basically.
and you can't get the car
because they throw
back.
it behind a fence on their own property.
Right.
And and I've noticed anytime not that we go over there a lot to events, but anytime we've gone over to Verizon Center for something, I've noticed an awful lot of tow trucks trolling through the area to find people who maybe parked where they should not have.
And those would be arrangements of a private landowner. So say there is a business downtown and people try to park in their lot to go to the Verizon. So they'll have an arrangement with a towing company that says, if you see anybody parked there after hours or whatnot, you have our permission to tow them, and therefore they can tow them and get their money. So it's a way they make money.
There's no question they troll.
Yeah.
Wow. So, all right, so now we're bumping all the way up to the Supreme Court.
Yes. Now, the reason it gets there, which...
That's pretty huge.
Yeah, the reason it gets there, as I said before, there is another state, and their Supreme Court, that state's Supreme Court, analyzed similar set of facts and said this federal law preempts the ability to sue the tow truck operator under the Consumer Protection Statute. New Hampshire Supreme Court, in my case, said no, it's not preempted. So now you have a divergent. Two different Supreme Courts of two different states are actually determining the same issue differently. And that's a case that can be appealed to the Supreme Court because there's a divergent,
That's staggering.
Yeah.
That's staggering. Now, what does it take? I mean, what does it actually take for somebody to get a case up to the Supreme Court? I mean, a lot of people are unhappy with court outcomes. There are probably thousands per day if you had them up all over the country.
Right.
And, I mean, all of them can't all of a sudden say, I demand the U.S. Supreme Court decide this. So how does it get there? What's involved in all of that?
You have to have a federal issue, number one. The
U.S. has to deal with the federal?
The U.S. Supreme Court is not going to get involved in a purely state matter in a state court. The New Hampshire Supreme Court has the final say. If the New Hampshire Supreme Court is dealing with a federal issue, whether it be a federal statute or like this is a preemption here, then that can go up on what's called a writ of certiorari, and you have to petition the U.S. Supreme Court for it to be accepted. And the Supreme Court has a screening criteria and whatnot. 0.05% of the cases get accepted.
That's all.
Very few cases get accepted. So it has to be something special about the case, and it has to apply to a lot of people, have importance, or in a case like this, it's federal preemption law that not only would apply to every state and having to do with towing or whatnot, but this law applies to the airline industry, the same type of preemption law that got out of the airline industry. So when the Supreme Court is analyzing a case, oftentimes they borrow the analysis. Okay, this statute is like that statute, and so we're going to analyze it and apply the legal principle the same. So this case potentially could have affected every motor carrier, every airline, but also some of the legal reasoning is out of ERISA cases, and those are employment cases having to do with insurance programs and whatnot. So this issue, the way that you interpret this statute, statutory construction, could apply to all kinds of different people. So that's why this got accepted. It was a federal preemption, this federal statute, and the way you analyze and apply this statute not only applies to this little guy's car getting towed out of this parking space, but could apply to every airline and other industries. So
now, given that a lot of time and money would be involved in all of this, by money I mean obviously lawyers have to get paid. I think we all would agree that you have to do a tremendous amount of research to get ready for a U.S. Supreme Court. So kind of two things are in my mind. Did they think that there was absolutely no possibility that you, on behalf of your client, who's just a normal, ordinary guy, would ever in a million years say, you know what, we're in it. We're in it till the end? Did they think that could possibly happen, number one? And number two, and maybe you can't even answer this, but I can throw it out there, do you think that maybe there were other people in cahoots outside of that one towing company trying to get something new on the books that would help that particular industry?
That's an interesting question and issue. I don't know if there were other people on the cahoots part of it, in cahoots to get them up there, because when we got to the Supreme Court and the briefs were due, there's a process by which other people who have interest in that particular issue can do amicus briefs. So they can file briefs saying, hey, court, can you hear from us too, because this affects our industry and we want to provide you case law to assist you in making the right decision.
Did
It's
that
an amicus
happen?
brief. There was a lot of amicus briefs in here, yes. But the Towing Association,
Now, how would they even find out about it?
it's all public record. There's a whole cottage industry of people who follow.
Follow
It's
public
called,
record?
if you Google it, SCOTUS blog, SCOTUS.
Oh, yeah?
Supreme Court of the United States, SCOTUS blog. It's a whole, website that's dedicated to the Supreme Court. It's cases. They have articles that analyze the issues, who the players are, whatnot.
And the national associations that towing companies would belong to and
Right.
such, no doubt,
They knew
have
about it.
people on staff who are kind of keeping
Right.
track of that, and it makes it into the newsletter that goes out all over the
But
country.
curiously, the National Organization for the Tow Truck Companies,
Yeah.
they filed an amicus brief for my side.
Really?
Yes, because the concern is if this was upheld, if this was preempted, then state law that applies would be preempted. The towing companies need the state law to sell the vehicles to get their bills paid.
Ah.
So the concern was that this federal law
again,
preempts the state.
another
Now the state
twist.
law that lets us sell them
Yeah.
to collect our fees might not be enforceable, so how are you going to sell it?
Another
We
twist.
got to go file suit now, get judgment, go to sheriff's sale, like a regular creditor will have to do, which is a long, drawn-out procedure. It increased the cost for the towing company. So the towing companies, are they in cahoots here? The towing companies didn't want this to be upheld.
Mm-hmm.
They were on my side in the amicus brief.
Amazing.
So did I get any indication that they thought, hey, if it got accepted to the Supreme Court, we'd just go away? I didn't really get that feeling at all.
No?
I think it was just their counsel that saw this when they filed in the Superior Court and they won. Wow, geez, we have something here. Let's
So you
run
thought he
with
was
it.
on a roll, probably.
Yeah. So they were surprised that the case got accepted. I was surprised, but fortunately for me, as you said, all the work that gets done. Public Citizen Litigation Group is a law firm in Washington, D.C. It's kind of like a Ralph Nader group, consumer protection group, and they look for these issues that are going up to the Supreme Court, and they take it as an opportunity to file amicus briefs, assist litigants
Neat.
to make sure that consumers' rights are protected. So in this
So
case,
they were able to give you a lot of
Right.
info?
I
That
was
was
the
good.
consumer protection person bringing it up, and if this went against me, that means a lot of consumers throughout the country might not be able to bring lawsuits under the consumer protection statute. So they helped me write the brief. They prepared me for everything. They were an invaluable resource, which was free to my client.
Great. But now, you would be, though, I mean, when it came time for the big game,
Yep.
you were going to be the one standing on your feet in front of the Supreme Court.
Most people don't do that.
But you did.
Most people, when they get contact with Public Citizen Litigation Group,
Yeah.
let them take over the whole thing.
But you did it.
I wanted to argue the case, and Mr. Pelkey wanted me to argue
So
the
now
case.
let me ask you this.
Yeah.
What the heck was it like preparing for that? I mean, that is so huge.
Preparing
So
is-
even though,
yeah.
I mean, you were getting help and getting a lot of help with the research and such, you still must have been in a situation that you wanted to know how every I was dotted and every T was crossed, so that the day that you stood before those folks, you had it down.
Oh, absolutely. I mean, it's a daunting task. I mean, all the Supreme Court judges are exceedingly bright.
Yeah.
They have a bunch of law clerks up there that are the top in their classes from the Ivy League schools, exceedingly bright, been doing it a long time. And the type of law that was involved here is not something I address every day in my practice.
Probably,
in
thank
fact,
God, huh?
I've never ever had to do a federal preemption case, let alone on the Motor Carrier Act.
Yeah,
So
yeah.
there was a steep learning curve. I needed to get down and learn the history of the Federal Aviation Act, which is in 1978 having to do with airlines. Then I had to learn about the Motor Carrier Act in 1994. And then because ERISA cases were pertinent to the analysis, I had to know about ERISA cases,
So
which
you must have read a lot of case law.
I read, hundreds of cases.
Yeah, you would
hundreds
have
of
to have.
cases. And
Yeah.
then there was like 8 or 9 amicus briefs that were filed on my side, so I had to read each and every one of those and then get up to speed. So there was a ton of work. And I have a busy, small, litigation practice. I couldn't just, shut down for a month
no, of
and
course
whatever.
not.
But
You still have to feed the kids and everything.
but for a week or two, I shut down, and I read the cases, and I was down in Washington, D.C. a week or two before doing moot courts, and basically holed up in a motel room, just reading,
Really?
and shutting the world out. Yeah,
That has to be massive. I mean, it has to be daunting.
daunting, but I tell people in a way it was relaxing.
Yeah?
I was very fortunate to be in a position to have the time to do that, to actually focus on one thing and to
I mean, it's huge.
put the
How
time
many people
in.
get to do that?
Right. And to do something that's, it's once in a lifetime type of thing. And but then also it's a challenge. It's, this is, it's
absolutely.
not an easy thing to do. So it's a challenge. So you have to step up and meet the challenge. So
Just sleep the night before?
yeah.
You did?
Yeah, I did.
Really?
I was probably reading cases. I had to be there earlier in the morning. Well, I had to actually take, the metro to go over, and my daughter was with me, and then my parents came
I
up.
heard you. Yeah, somebody told me some of your family went down to watch it.
So I had to get there. So I was probably, shutting the lights out by midnight.
No kidding.
Yeah, but right up to
See,
the
I would have
last
thought you
minute.
would have been hyper, and unable to sleep.
I have the ability to block out stress and block things out. So, come game time, I really don't have a problem. I was prepared. I knew I was prepared.
So you didn't have butterflies when it came time to walk through that big door, huh?
No.
No?
I had more butterflies, the week before when I was doing the first public meeting for the town meeting, because I had never done one before. I had more butterflies there because
I want to tell you, Bedford could get pretty wild,
Well, there's lots of things that are coming at you at once. Here, I knew the process. I had gone to the Supreme Court. I did my homework. I was prepared.
Plus, you get to leave the Supreme Court.
Right.
Whereas Bedford, you're stuck for a while at least.
And it's only going to last a half an hour. It's going to be over within a half an hour. So
it does only last a half hour?
It's a half an hour oral argument.
Isn't that amazing? I mean, all the work and time and such that goes into that.
But I took 10 minutes of my time and gave it to the Solicitor General because they came in on my side. They filed an amicus brief and took over 10 minutes of my oral argument. So, no, when I was there, I was quite comfortable. I had done all the work. I was familiar with all the arguments. And it was funny. The Solicitor General who was arguing for the United States, it was his first case before the U.S. Supreme Court. Wow. Now, he'd been involved in a bunch of cases, but it was his first U.S. Supreme Court case.
Him standing there, huh?
And the gentleman who was arguing it for Dan City, it was his first time before. He was actually out of Vermont.
Wow.
But he was part of the firm that was representing Dan City. They have a New Hampshire practice and a Vermont practice. His first case. But I was talking to the U.S. Solicitor General, the assistant, as we were sitting down, and he was saying, we were the second argument. We had to wait through the first one. And he said, I don't know. He was very nervous and he was shaking. He says, I may have to leave to go to the bathroom. I haven't drank any water. But, if I leave, don't worry, I'm coming back. So it was forewarning. I just looked at it, I said, Lewis, calm. Just,
you have to take a deep breath.
Yeah. So I was actually pretty calm that day. I have the ability to just, I don't know, just
compartmentalize.
I'm one of 10 kids. I've always had chaos around me.
Oh, that's true.
I'm able to
See,
focus
that's when it
on
would
the
come
task
in
at
handy.
hand.
Yeah, because when you got that many kids in the family, you've got to be able to do your own thing and,
it was,
like you say, forget the chaos.
It's funny that morning when I went, because my parents had come up there at a different
They must have been thrilled.
Yeah. Oh, that's a story in and of itself.
Oh, I bet.
But I picked them up and I to get in the envelope, get into the elevator, and I just looked at them and said, "Hey, Mom and Dad," I said, "Forgive me. I get into my trial mode. When I get into my trial mode, I'm here. I'm thinking.
Really,
So excuse me for the next hour. I'm not going to talk to you."
Yeah.
And that's what it was.
Well,
all the way through, going on the metro. I was just. Going through it in my head,
you have to focus.
get into your own zone.
Yeah, you have to. You couldn't do it otherwise.
Yeah.
I mean, right now the Olympics are on TV, and not that I sit and watch them all, but when the ones I do catch, you can even see that when it's their time. You know that there's the whole world outside of what they have to do for the next 3 minutes, 5 minutes, or whatever doesn't exist.
Yeah, so it was relaxing in a way because that's all I had to focus on, and it was probably nerve-wracking about a month beforehand, realizing all the work I still needed to do.
Yeah, I can imagine.
And I'm trying to find the time, how do I actually get the time to do it? And then logistically, you get down there, do this moot court. I did the first moot court for UNH Law School. They had never done one before.
Really?
My daughter was a law student there, and they were doing their writing class, and they were talking about, well, you have to go up to the New Hampshire Supreme Court and watch it, and the teacher's assistant who was talking about it said, no, they're actually interesting. I was up there last year, and there was a case about a guy's car getting towed, and my daughter goes, that's my dad's case, and it's going to the U.S. Supreme Court.
For her.
Yeah, and then when they heard, what? It's going to the U.S. Supreme Court? So they called me up, and I helped them get their moot court established up there. So that was fun. It was a thrill for both me and my daughter. So.
Well, I mean, you'll probably be getting, after effects of that for a lot of years.
Well, even to today, I mean, as you said, there are not too many New Hampshire lawyers who get the opportunity to argue for the U.S. Supreme Court.
Nationwide, there aren't too many.
A lot of times when they have cases up there, they hire firms and people who are frequent flyers.
Yeah.
They'll hire the people who argue the cases. The day before, when I watched, just to get the lay of the land and get comfortable, I watched oral argument. One of the oral arguments was a case out of New Hampshire. It was a products liability case on a pharmaceutical company, but they hired counsel. They hired a larger law firm to handle that case. And the other side, the pharmaceutical company, hired counsel who, argued the case. So.
Now, here's a personal question. After you walked out of there, I mean, obviously you knew you weren't going to get an opinion right away, but when you walked out of there, what'd you do? Did you go out and have a beer or what?
Well, actually, I was with my parents, and my son and my daughter came with me, and we had, Bill Greiner, who's a good friend of mine, actually came down.
Did he?
He came down. He's a good friend and client of mine, so he came down for the oral arguments as well. And he had arranged for Kelly Ayotte office to give us a tour of the Capitol building. So my mother and my,
they must
we
have
got
loved that.
the private tour of the Capitol, got to meet with Kelly Ayotte, who had argued a case several years before that, before the U.S. Supreme Court.
That's right. I forgot that. Yeah.
So I didn't get to have a beer till well later. So I got to have the tour, which was great. But that was great for my parents. It was. Oh,
that had to be the thrill of a lifetime. I mean,
well, I'll tell you, to this day.
You're that baby, no matter how old you get. You're that baby.
I remember my dad, because Kelly Ayotte was, of course, we're kibitzing a little bit, her experience.
Sure.
You get a quill, so we're part of the quill club. So we're talking about the experience. Well, my father got right in there and he told her, he was the best lawyer in there. When he was talking, they were on the edge of their seats and blah, 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 blah. He says,
no bias.
Yeah, no bias there. And so I'm just going, oh, geez, Dad. And so I told people, when I tell the story, I'm going to remember it like my dad remembered it.
Yes, absolutely.
Yeah, they're very proud.
Absolutely.
Very proud. Yeah.
So I know they finally came with their decision. Tell us what happened.
I got a unanimous 9-0 decision.
Unanimous,
yeah. So I felt very good coming out of the oral argument. Yeah, it was very evident when I first started. One thing, I've done a lot of cases for the New Hampshire Supreme Court. I've done a First Circuit Court of Appeals in the federal court, obviously never before the U.S. Supreme Court, but sometimes it's very difficult to determine which way the court's leaning.
I can imagine.
What's happening there is some of the judges are asking questions of you. They give you softballs, if you will, because they want you to answer in a certain way. Not for their own education. What they're trying to do is get the point across to another judge. They may not be analyzing the case the way they are. So they kind of use you, to get to the other judge. So it's very difficult, but it was clear to me when we first started that the other side got to go first. I was the respondent, they were the petitioner. He was having a real hard time, and the judges were really taking him through the paces, and it was clear to me that there was a number of judges that just was not buying that argument at all. When I got up, of course, they're going to give me some pointed questions, but I thought I had a much better reception, and I thought I did a very good job in answering the questions, so I felt confident coming out of there we're going to win, but I didn't. 9-0 was like, wow.
I know.
I'm going to retire now because
I know.
I haven't lost a vote at the U.S. Supreme Court.
I
can
know,
retire
that's
now.
Amazing. Because that doesn't happen often, I don't think.
No, but curiously, I mean, in that same quarter when they were issuing the decisions, there was one other unanimous decision. But no, there's a lot of split decisions, but it doesn't happen too often. But I was just pleased at the outcome.
Now, after all of this, and I mean, at this point, it has reached over 6 years. Now it's almost 7 since it happened. Has poor Mr. Pelkey ever gotten any personal satisfaction?
Not yet. Here's the problem. People don't understand when they ask me about this. They think the case is over. I won at the U.S. Supreme Court, of course. But you have to remember, this case got started because my case got dismissed. Got dismissed out of Superior Court. New Hampshire Supreme Court overturned that, which means I can go back to court and have a trial. However, the New Hampshire Supreme Court got appealed to the U.S. Supreme Court. So when the U.S. Supreme Court upholds the New Hampshire Supreme Court, all that means is I go back to the Superior Court and I can have my trial.
Oh, for goodness sake.
So I am now scheduled for trial in the first week of March on this case. So it took a year and a half. I got dismissed. Then it goes up to the Supreme Court. New Hampshire Supreme Court, that takes about a year. And then up to the U.S. Supreme Court, that takes 6 months to a year. And now I'm coming back to get on the trial docket, back again in the Superior Court.
So now I would assume what's coming up, there would be something in there that he's made whole again financially.
Well, we have a
for his
mediation
loss and
coming up
such.
to see if we can settle the case, because the
Yeah.
insurance battle I talked about
Yeah.
before, that's been resolved. I don't know how it got resolved, but it's, so now we have people who want to settle the case and see if we can settle the case. So we're going to have a mediation at the end of this month, and if that does not settle the case, then we'll have a trial first week of March.
Wow.
If I win a trial, then Mr. Pelkey would hopefully get compensation, not only from Dan City, but Colonial Village is still a defendant in that case as well.
There should be.
So he'd be able to get paid for his car. I did a claim under the Consumer Protection Act, which would allow us to get up to triple damages and attorney's fees and costs. And that's going to be the big part. The attorney's fees and cost award
Of course, yeah,
is going to
that's big.
encompass this
Yeah.
whole,
Yeah.
shebang.
Now, if you lost, that means you don't get paid?
Get zero, yeah. Yeah.
If you
Well,
win,
technically, Mr. Pelkey is still responsible for my fees, but Mr.
Well, yeah,
Pelkey is a
but you
man
know,
on a
yeah,
fixed
exactly,
income who does
That's
not have the
gonna happen.
resource to
Yeah.
pay that.
Now, if you win,
I've underwritten all the expenses to it anyways.
if you win, who pays?
The
Will it be
other
the
side,
insurance company or the towing company or
well, I'm not sure about
Everybody?
Colonial Village and their insurance company, but Dan City
yeah?
had the battle with their insurance company. I'm not sure what their arrangement is, but the court would then determine whether I get my attorney's fees and costs or how much that is. The jury would determine the amount of damages. The car was worth $12,000. There was some personal property involved too. But then the judge would get to determine if it's double or triple. So it really depends on how the award comes down. I have a separate case against
And
Colonial
this will
Village.
definitely be a judge decision, not a jury?
Jury decides some of the
it
issues,
will
but
be.
some of
Okay,
them have
I'm
to
sorry.
be decided by the judge. Consumer protection, whether it's triple damages,
Yeah.
and there is that 540A action against the landlord, which again is a split between the judge and the jury making decisions.
Amazing. 7 years later.
Yeah.
I just looked at the clock and I can't believe it. We've got to close. Brian.
Now, some of the twists and turns we didn't get into.
I know. We can do a follow-up after this other thing is over so people can find out what finally
Well, I'd be
happened.
happy to tell you the follow-up.
Well, I'll tell you, that was an incredible story. Thank you. To all of you out there, we are out of time. And there you have it, at least up until what comes next. Atty.Brian Shaughnessy of Bedford, New Hampshire, went all the way to Washington, D.C. to wage war for the little guy. A guy that, when you think about it, could have been any one of us. Anyone. What an incredible achievement. And I've only got a couple seconds left, so let me say this. What a heck of a testament to telling it like it is when such might seem to be a lost cause. And that's exactly what Brian did. He told it like it was, and he's still telling it like it is. And that's what we're all about. Thanks so much for watching. Until next time, bye-bye.